Edward J. Blaustein Jurisprudence Lecture. Does the world need an international constitutional court? Richard Albert. Abstract. Today democracy is declining around the world, and so is faith in domestic institutions. Many strategies have been suggested to fight back against the tide of authoritarianism, but the idea of creating an international constitutional court has yet to catch fire among defenders of democracy. In this lecture, delivered as the Edward J. Blaustein Jurisprudence Lecture at Rutgers University on May 18, 2022, I explore the origins of the proposal for an international constitutional court. I discuss the structure and powers of this proposed tribunal, and I evaluate how to design an international constitutional court for success. I conclude that the court, if ever it is created, should be limited to issuing only advisory rulings. To be sure, creating this international constitutional court is a Hail Mary play. But it may be needed now more than ever. Contents. Introduction, Global Jurisdiction 2. I. The Modern Origins of the International Constitutional Court 5. A. The Project and its Purposes 5. B. Global Trends in Democracy 6. 2. Designing an International Constitutional Court 8. A. The Architecture of the Court 9. B. A Constitution for the World 11. 3. The Possibilities for an International Constitutional Court 12. A. 3 Problems, Authority, Enforcement, Coordination 15. B. 1 Path Forward, Advisory Rulings 20. Conclusion, 5 Principles for an International Constitutional Court 22. Richard Albert, William Stamps Farish Professor in Law, Professor of Government, and Director of Constitutional Studies, the University of Texas at Austin. Email, richard.albert@law.utexas.edu. This text was delivered as the Edward J. Blaustein Jurisprudence Lecture at Rutgers University on May 18, 2022, as the lunch and keynote address at the Symposium on International Law and Constitution Making, organized jointly by the Rutgers Center for Transnational Law and the Diego Portales School of Law. I am grateful to the symposium organizers, Jorge Quintes and Domingo Lavera, for their invitation to deliver this lecture and for hosting this marvelous day-long event, and I thank symposium participants for their helpful comments and questions. Introduction, Global Jurisdiction. When he became president of France, Charles de Gaulle lobbied Parliament to pass a constitutional amendment he believed was crucial to securing the legitimacy of the Republic. He had been elected by an electoral college of elites, but wanted future presidents to be elected by a direct vote of the people. 1 Parliament disagreed, rejected his proposal, and decided to keep the electoral college. 2 Undeterred, de Gaulle resolved to find another way to amend the constitution. De Gaulle went over the heads of parliamentarians and appealed directly to the people. He held a national referendum asking his fellow citizens to amend the constitution to change how presidents are elected in the country. 3 Referendums are of course an appropriate way to amend a constitution, provided the constitution authorizes their use. 4 Yet there was a problem in this case. The French constitution required all amendments to begin in Parliament, and Parliament had already said no to de Gaulle's proposal for electoral reform. The battle lines were drawn. De Gaulle appeared not only to be defying the all-powerful Parliament, but also violating the constitution. De Gaulle's gambit attracted fierce opposition from all corners. In the heat of the moment, de Gaulle's unconventional referendum was described not only as unconstitutional 5, but even more seriously as a constitutional coup d'état. His choice to bypass Parliament provoked near.
C'est J. La réforme constitutionnelle, revue des deux mondes.
Universal outrage among both politicians and jurists, 7 including from most political parties. 8 Yet de Gaulle won the referendum with the support of 62% of ballots. 9 When the political waters had calmed after this historic vote, the question on everyone's mind was whether de Gaulle's victory in his irregular referendum would be recognized as a valid constitutional amendment. The constitutional controversy made its way to the Constitutional Council of France. The question for the council was whether de Gaulle's amendment by referendum was constitutional. Most believed the answer was number 10, but the council refused to answer the question. The council instead declared that it had no jurisdiction to rule on a matter involving the will of the people as expressed in a national referendum. 11 This outcome was a triumph for de Gaulle. The council dismissed the case on jurisdictional grounds. The referendum was treated as a valid constitutional amendment. The text of the French constitution was altered to reflect the new rule of direct popular vote in presidential elections, and since then presidents have been elected directly by the people. The pivotal moment in de Gaulle's ploy was not his choice to break the Constitution's rules of amendment. It was the Council's decision to decline jurisdiction. The Council gave de Gaulle a clear path to remake the French Constitution, freed from the legislative oversight the Constitution requires for attempts to reform the country's higher law. De Gaulle accomplished his goal, rewrote the electoral procedure, and left those opposed to his plan with no further avenue for appeal. Serge Burstein, The Republic of de Gaulle, 1958 to 1969, at 71, Peter Morris. But imagine there had been a higher court of appeal. Not a regular court, but a special body dedicated specifically to claims involving democracy, the rule of law, and constitutionalism. Imagine further that this court were an international body whose members had been selected for the sole purpose of guarding universal values and norms of government. Armed with global jurisdiction to hear controversies arising from all countries, this tribunal, an international constitutional court, would have had jurisdiction to answer the questions the Constitutional Council of France chose not to answer. Was de Gaulle's amendment by referendum constitutional? Today the idea of an international constitutional court is both far and near. It is far from reality because it is virtually inconceivable that the countries of the world could ever find agreement on how or even whether to create such a court. Yet it is simultaneously near to reality because there already exists an intricate web of global and regional supranational laws and adjudicatory bodies that suggest how such a court could function were it someday created. Many questions nonetheless remain unanswered about what an international constitutional court would need to be successful. Who would the judges be? How would they be chosen? Who could file a suit in the court? And what powers would the court have? The idea of creating an international constitutional court is a Hail Mary play. But this special court may be needed now more than ever, at a time when democracy is declining precipitously around the world, and so is faith in domestic institutions. The modern origins of the International Constitutional Court. The seeds for an international constitutional court were planted in a French newspaper in 1999. In his provocative essay, For Liberation, Mohamed Monsef Marzouki rang the alarm on what he saw around the world: authoritarian states attacking democracy and the rule of law, violating inalienable rights, holding rigged elections to give themselves a veneer of legitimacy, and reforming the constitution to consolidate their power and to harm their opponents. A. The project and its purposes. Marzouki had taken the baton from George Lietvo. At the height of the Second World War, Lietvo exposed how political actors were exploiting formal institutions to achieve non-democratic ends. For Lietvo, this amounted to fraude à la Constitution, a nefarious intent to defy democratic values according to strict and legalistic adherence to democratic procedures. Half a century later, Marzouki reminded us all that constitutional fraud was still evident all around the world. For him, here was the urgent problem facing the international community: how can we defend democracy from crafty political actors who manipulate their own constitutional rules while proclaiming a commitment to constitutionalism, democracy, and the rule of law? In his essay, Marzouki sketched in broad strokes his idea for a court to protect democracy. He suggested the International Court of Justice and the International Criminal Court as models for this new court, and proposed that the court should have one all-important objective in the near term: to rule on the legality of elections around the world. In the longer term, the role of this new court, which Marzouki labeled as an international constitutional court, would be to eradicate dictatorships and to guard democracy from defeat. But Marzouki wisely wondered aloud about what body of law this new court would be called to enforce. In other words, what jurisdictional authority would this international constitutional court exercise? He had an answer. The new International Constitutional Court would be the guardian of the three major texts of higher law in global governance: 1. The Universal Declaration of Human Rights; 2. The International Covenant on Civil and Political Rights; and 3. The International Covenant on Economic, Social, and Cultural Rights. Marzouki saw in these three higher laws a robust commitment to universal values, foundational moral principles, and to specific directives for state actors that would together set a standard for all states to follow. The role of the new International Constitutional Court would be to defend these values, principles, and directives. B. Global trends in governance. Two major trends have emerged in the years since Marzouki published his pivotal essay on what he regarded as the pressing need for an international constitutional court. First, Marzouki has been proven right: the problem of constitutional fraud has only worsened. Democracy has declined every year 2006, plunging the world into a long democratic recession. This trend shows no sign of reversal. On the contrary, the global decline in democracy has only grown steeper and faster. 20 Today, only 6.4% of the world lives in a full democracy. 21 Dictatorships are far more populous than democracies. Dictatorships now govern 70% of the world, pulling us back to the lowest levels of democratic governance since 1989, before the fall of the Berlin Wall. 22 Sadly for us all, the verdict is undeniable: democracy is losing all over the globe. 23 The second trend is a direct response to the first. The distressing decline of democracy has had the positive consequence of focusing the energies of scholars and political actors on diagnosing the problem of constitutional fraud and brainstorming ways to rescue democracy. The phenomenon of abusive constitutionalism is the direct descendant of fraude a la constitution, as it warns us that the core problem, then, is that it is fairly easy to construct a regime that looks democratic but in actuality is not fully democratic. 24 solutions to the problem are hard to find because it is possible for authoritarians lawfully and constitutionally to use of the mechanisms of constitutional change in order to make a state significantly less democratic than it was before. 25 These constitutional changes sometimes slice so deeply into the heart of the Constitution that we cannot call them mere constitutional amendments. We must call them constitutional dismemberments because they do violence to one or more of a Constitution's essential features, for instance its fundamental rights, its basic structure, or a core feature of its identity. The puzzle, then, is how to spot and stop autocratic legalism before it is too late. We now have academic. Freedom House, new report, The Global Decline in Democracy Has Accelerated, March 3, 2021, at HT. Resources at our disposal to identify threats to constitutionalism, to defeat authoritarianism, and to build safeguards for democracy. In addition, the Biden administration's new Summit for Democracy and its associated initiatives send strong signals to autocrats that democratic leaders around the world are joining forces to take deliberate steps toward global democratic renewal. However, among the many strategies for how to fight back against the tide of authoritarianism, the idea of an international constitutional court has yet to catch fire among defenders of democracy. Designing an international constitutional court. From the day Marzuki wrote his powerful essay about establishing a new global tribunal in 1999, he never relented on his idea for an international constitutional court. He was a devoted Democrat, a committed constitutionalist, and a champion of human rights. But there was little he could do to put into motion the creation of the court. After all, he was an essayist, trained as a physician, with no official executive role in government. Things changed 12 years later in 2011. Marzuki became president of Tunisia. Soon after he was sworn into office, he convened and chaired an ad hoc committee for the establishment of an international constitutional court. Over a decade after Marzuki first suggested this tribunal, he finally found a larger platform to take his idea one step further toward reality. A. The architecture of the court. His committee issued an impressive report explaining why and how to create the court. It is worth reviewing the more technical aspects of the committee's vision for an international constitutional court, including its composition, function, jurisdiction, and authority. Some may be underwhelmed by these details, while others will see great promise in its broad strokes. Most, I suspect, are likely to fall somewhere in between, which is where I find myself. The court is to have 21 judges elected by the General Assembly of the United Nations. The Assembly would select these 21 judges from a closed list of 42 candidates chosen by a college of judges that would include representatives from the International Court of Justice and the International Criminal Court. Those 42 candidates would themselves have been drawn from a list of roughly 200 nominees, one from each of the member states in the United Nations. The court is to have two principal functions, giving advice and resolving disputes. In its advice-giving function, the court would issue advisory opinions at the request of governments, political parties, professional groups, non-governmental organizations, and multinational organizations at the international, regional, or sub-regional level. The court would be authorized to give advice on texts or draft texts related to democracy and rights. If the court determines that a given petitioner has standing, the court is to issue a declaration on whether the text is consistent with democracy and rights. If the court wishes, it may suggest revisions to the text in order to bring the text into conformity with its standards. The court has 6 months to issue its opinion. In its dispute resolution function, the court is to rule on what the report defines as serious violations of democratic principles and democratic conditions for elections. The court may hear complaints from political parties, professional groups, non-governmental organizations accredited by the state as part of an electoral process, and multinational organizations at the international, regional, or sub-regional level. The court may be petitioned only after the complaint has been evaluated through all available domestic avenues. When a complaint is brought to the court may attempt to mediate the dispute. Failing that, the court is to issue a judgment on whether the acts or facts respect democracy and rights. The judgment is intended to be binding on the state implicated in the dispute, meaning that the state is to implement the ruling of the court. In exercising both of these functions, advice-giving and dispute resolution, the court is to be guided by what the report describes as the principles and rules relating to democracy and universal and regional civil liberties. 41. But what exactly does democracy demand, and which civil liberties will the court protect? The jurisdiction of the court is to extend broadly around the world to require the court to enforce relevant rules in the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the Treaty on European Union, the European Convention on Human Rights, the Charter of the Organization of American States, the American Convention on Human Rights, the Inter-American Democratic Charter, the Constitutive Act of the African Union, as well as the Harare Principles. This is a vast portfolio for any court. B. A constitution for the world. According to the committee, the impetus for an international constitutional court is twofold. First, states have an obligation to respect principles and rules relating to democracy, to the rule of law, and to periodic, competitive, and genuine elections, and states should be held accountable for how well or poorly they fulfill that obligation. The second impetus derives from the first. Although states carry this obligation, much of the world nonetheless lives in regimes that violate this obligation. Point 44 Authoritarian states are of course the main culprits, the ones that most blatantly breach the basics of democracy. But the committee raises a red flag also for democratic states. Many democratic states routinely fall short of the expectations we have for democracy. Neither of those 2 points is controversial. States have an obligation to respect democracy, but many do not fulfill that obligation. That is not controversial. But what is controversial is the long-term objective the committee has for the court. To its credit, the committee does not conceal that objective. The committee states directly and without qualification that its goal in creating this court is to internationalize constitutional law. In other words, to create and to enforce a constitution for the entire world, a world constitution. Here is how the committee explains its mission. Emphasis should be laid upon the internationalization of constitutional law, in other words, upon the principles of constitutional domestic laws common to nearly all the nations. They are norms relative to the fundamental rights and freedoms of the citizens, to the democratic basics of political power, and to the organization of the political and jurisdictional power. An international constitutionality definitely exists. The role of the court, then, will be to determine what qualifies as international constitutional law, to separate what falls within the scope of a constitution for the world from what extends beyond a global constitution, and then to enforce that world constitution in claims brought to the court. Can there ever be a world constitution along with an associated world court to enforce it? The possibilities for an international constitutional court. Years have passed since Donald Trump lost the 2020 United States presidential election, yet many Americans continue to doubt that Joseph Biden is the country's legitimately elected president. Despite the dozens of rejected lawsuits challenging the result of the 2020 election, 26% deny that Biden won fairly, while 16% do not know what to believe. The election has deepened fault lines in the country, with grave consequences for law and politics. States have changed their electoral laws on ballot access, districting, and voting requirements. Democrats and Republicans are farther apart now than at any time in the last half-century. And agreement remains elusive on who should be held accountable for the unprecedented attack on the U.S. Capitol on January 6, 2021. Is there anything that could have stopped America's steep spiral into deeper mutual distrust and suspicion in the aftermath of the 2020 presidential election? Imagine if instead of challenging the result of the 2020 election in U.S. courts, the former president and his allies could have brought their legal claims to this international constitutional court. Whatever the outcome of those suits, this path could perhaps have neutralized allegations of judicial partiality toward either side, since none of the judges could be said to owe their position to any political party in the United States. This path would have moreover removed the matter from the polluted ecosystem of American politics, allowing the tribunal to resolve the dispute from a distanced third-party perspective. This is not say, however, that this foreign tribunal would have brought political peace to the United States, nor that it would have fully convinced either side to accept the lawful outcome of the election. Some are quite simply unpersuadable that the election was free and fair, while others will never believe that the election was anything but. There is another reason why this path might not have worked. The nature of the International Constitutional Court as a foreign tribunal might have predisposed large segments of the American population to deny the legitimacy of the court itself and of its judgment, whatever the outcome. Perhaps, then, recourse to an international court for democracy would not have calmed the troubled waters of American politics. But perhaps it could have reassured at least some Americans of the legality and legitimacy of the presidential election, even if many remain skeptical still. Claims of illegality in the 2020 presidential election continue to influence politics today in the United States. The claims have been settled by courts in the realm of law, and all courts have reached the same conclusion: there was no illegality in the 2020 presidential election. But these claims remain unsettled in the realm of politics, despite many court rulings in the United States. Now that we know more about the proposal for an international constitutional court, how it would work, and how it would be constituted, we can pose the question again: what if the former president and his allies could have brought his claims to this new international constitutional court? First, we should determine whether the court would even hear such a claim. Recall the court's two functions, giving advice and resolving disputes. A claim brought to the court on these circumstances would call upon the court's dispute resolution function. But who would have had standing to bring the claim? According to the committee's report, the court could hear complaints from a variety of claimants, including political parties. Here, the Republican Party could have lodged a formal complaint to the court, but only after all domestic alternatives had been exhausted. This means that the Republican Party could not have filed its claim until the former president and his allies had tried every possible avenue within the American legal system, culminating with a judgment from the Supreme Court of the United States. Only then could a claim have been filed and heard at the International Constitutional Court. Assume that all boxes are properly checked, and that the claim is properly filed at the court. Could a judgment from that court have brought constitutional peace to the country? The answer is no. Whatever the court ruled on the claim brought by the Republican Party to challenge the 2020 presidential election, that ruling would not have changed the minds of persons on either side. It might have influenced those who were unsure about what to believe, but for the most part the judgment would have made no meaningful difference to the poison politics in the United States, even though the International Constitutional Court was designed to hear disputes about violations of democracy, including specifically allegations of electoral irregularities. But just because the court would not have made a difference in this American case does not mean that the idea of an international constitutional court must be rejected altogether. On the contrary, this hypothetical American example helps us refine the parameters within which the court could actually work. A. 3 problems: authority, enforcement, coordination. This constitutional conflict involving the 2020 U.S. presidential election highlights one major challenge to the viability of an international constitutional court: the problem of authority. The committee proposes to make the International Constitutional Court an organ of the United Nations. It would be created by the United Nations, its members would be chosen by the United Nations General Assembly, and it would apply texts of higher law in the United Nations. When the UN was created, there were high aspirations for it. But the aspirations for the UN have so far exceeded its achievements. And there are increasing signs of disenchantment with this body. The failures of the UN are well known, and each is a real catastrophe. Rwanda, the oil for food program in Iraq, civil wars in South Sudan, Syria, and Yemen, the Rohingya crisis, Kashmir, Haiti. It is a long list. The most recent failure is Russia's attack on Ukraine, an attack that the UN is powerless to stop because Russia's permanent seat on the Security Council gives it veto power over anything the UN does. All of this paints a portrait of tragedy, and undermines the authority of the UN as a body that can help manage global governance. Nonetheless, I continue to believe that the UN holds hope for bringing peace, stability, and prosperity to all parts of the world. But I may be in the minority. And that is why the idea of an international constitutional court housed in the UN confronts a problem of authority. This problem of authority is significant. Yet an even bigger challenge, confronting the dream of an international constitutional court, may be the problem of enforcement. When the International Constitutional Court speaks, will the wrongdoer listen? Imagine a democracy-promoting party files a claim in the International Constitutional Court arguing that a recent election in an autocratic state was undemocratic. Imagine further that the court hears the case and concludes that the authoritarian government engaged in clear and flagrant violations of standards of electoral fairness and integrity. Then what happens? Probably nothing. The election result is unlikely to be reversed. Nor will a new election be called. The country will continue to operate as it is, under an authoritarian state that rigs elections. But sometimes the authoritarian state might comply, if only in a limited way. That is what happened in Burkina Faso, an authoritarian state landlocked in Western Africa. The story begins in October 1987, when Blaise Compaoré seized power in a coup d'état that removed President Thomas Sankara from office. A few years later, in 1991, Compaoré was elected president, then again in 1998, and again in 2005 and 2010. Along the way, Compaoré changed the rules of presidential eligibility to allow himself to keep running and winning. He tried again in 2014 to extend his eligibility to run for a fifth consecutive term. But that amendment attempt provoked riots, protests, and anger across the land. Ultimately, Compaoré resigned from the presidency. A caretaker government was installed to help manage the transition through the upcoming election. During that transition, political parties worked together to create a National Council of Transition that would have legislative authority to keep the country running. The council chose to make dramatic changes to electoral eligibility for the upcoming elections. It declared in a new electoral law that several categories of persons would be ineligible to run in the next election. One of those categories consisted of all those who had been supportive of the former regime's efforts to violate the rules of democracy, specifically all persons who had supported anti-constitutional change, in violation of the principle of democratic change, notably in violation of the principle of the limitation of the number of terms of political presidential power. Some of the prospective candidates who had hoped to run in the next election brought a claim to the ECOWAS Community Court of Justice along with several individual citizens. ECOWAS stands for the Economic Community of West African States. ECOWAS has its own regional supranational court. Its mandate is to ensure that member states observe the law and principles they have agreed to respect. The court has jurisdiction similar in kind to what is envisioned for the International Constitutional Court. The petitioners argued that this new electoral law denied them the right to participate in elections. 53 They cited the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the African Charter on Human and People's Rights, the African Charter on Democracy, Elections, and Governance, as well as the ECOWAS Protocol on Democracy and Good Governance. The court agreed with the petitioners and issued a ruling requiring Burkina Faso to allow the prospective candidates to run. The court ruled that there is no doubt that the exclusion of the political parties and citizens from the forthcoming electoral race is discriminatory and hardly justifiable in law. The court added that forbidding any organization or person from presenting its candidature for elections on the grounds of being politically close to an ousted regime, whereas the person concerned has not committed any particular offense, is tantamount, in the view of the court, somewhat, to an offense for holding an opinion, which is obviously unacceptable. Shortly after the ruling, the acting president of Burkina Faso announced that the country would comply with the ruling. But then the matter went to the Constitutional Council of Burkina Faso, the highest court in the country, and the council went over the head of the International Court. The council disqualified election candidates on the basis of the electoral law that the ECOWAS court had earlier declared invalid. But the Constitutional Council did allow some of the previously disqualified candidates to run. In the end, the domestic court simultaneously enforced the International Court's ruling in one part while defying it substantially in another. This illustration from Burkina Faso suggests an alternative to a single, super-international constitutional court. If what we care most about is compliance and enforcement, perhaps regional constitutional courts might work better. The interdependence and commonalities among countries within the same region might make it more likely that a regional court of their peers could persuade a given country to comply with a ruling issued by a court rooted in the region that the country had made a mistake. These countries might respond better to a homegrown local tribunal constituted of local persons than to a foreign body, located somewhere out there and staffed by persons not from here. A regional constitutional court could balance the need for a distanced, arm's-length evaluation of a claim of wrongdoing within a given country, while not relying on a court far, far away, unfamiliar with the local realities of the country and its people. This idea of regional constitutional courts might alleviate the problem of enforcement. Still, we might worry that regional constitutional courts would fail to fulfill the single most important objective of the proposal for an international constitutional court, which is to build and enforce one world constitution. It is therefore worth asking, would having regional constitutional courts really undermine that goal of having one world constitution? Perhaps not. There can be a single world constitution, with several interpreters of that constitution, located in different parts of the world, each drawing from its own local, regional traditions and histories to implement universal principles and values. It could be the case that one regional constitutional court interprets the right to free expression differently from how another interprets it. But both courts would be upholding the same right, just with local variations. This would not be unlike the doctrine of the margin of appreciation in the European Union. There is also a practical reason why a system of regional constitutional courts might work better than one single international constitutional court. That reason is quite simply that there already exist tribunals around the world that operate as constitutional courts within their region. That infrastructure has already been built, it has been populated by people and practices, and it is working to achieve its purposes. True, that infrastructure of regional constitutional courts may not be functioning at its highest level, but why not just improve upon this existing architecture instead of building something that could in the end be duplicative? Current illustrations include the African Court on Human and People's Rights, the European Court of Human Rights, and the Inter-American Court of Human Rights, for example. Their purposes are much the same as the ones envisioned for the International Constitutional Court. The existence of regional courts currently operating around the world opens the door to a different problem. Not a problem of enforcement nor one of authority, but rather a problem of coordination. How should courts exercise their powers when their jurisdiction overlaps? The challenge might be especially pronounced for the member states of the European Union. They have their own constitution, and they are subject to the jurisdiction of their own supranational courts, and now they would also have the overhang of an international constitutional court. The problem of coordination would be considerably easier to overcome in countries where there is no supranational regional court operating at the moment. Still, these are three major problems standing in the way of an international constitutional court. The problem of authority, the problem of enforcement, and the problem of coordination. Not to mention the problem of political will, which does not exist today to create such a court. B. One path forward, advisory rulings. Remember that the ad hoc committee's report suggests two functions for the court. One is to resolve disputes. That is principally what we have been discussing so far. Can an international constitutional resolve disputes in a way that will be treated as binding, seen as legitimate, and received as valid? I am not convinced this is a plausible path forward for the court, due largely to the three problems I have identified, the problems of authority, enforcement, and coordination. But the second function could be the right path forward for the court, if indeed the court is ever created. And that is its advice-giving function. The court could hear claims of wrongdoing in rights protection, elections, or as relates more broadly to democracy. But rather than issuing an order that is unlikely to be followed, the court would instead issue an advisory ruling outlining its understanding of the facts, along with what the court believes democracy requires according to the expectations set out in the three fundamental texts in global governance. 1. The Universal Declaration of Human Rights. 2. The International Covenant on Civil and Political Rights. And 3. The International Covenant on Economic, Social, and Cultural Rights. The jurisdiction of the court would not change. But it would be limited to issuing advisory rulings only. One might think that this would make the court toothless and ineffectual. Maybe, but not necessarily. Because sometimes advisory judgments can have a catalytic effect in constitutional politics. They can send a strong signal of wrongdoing around which the opposition can mobilize support, about which media can write and report, and which laypersons can read for themselves to see how the conduct of incumbents in their country measures up to standards for democracy. Think again of the American case involving claims of illegality in the 2020 presidential election. If the claim had been brought to this foreign tribunal, the court would have arrived at the same conclusion as the U.S. domestic courts, that the election had not been stolen, and that President Biden is the legally and legitimately elected president. That is the correct ruling. Still, that ruling would not have quieted all critics. But it could have been an additional source of evidence that political actors in the United States could highlight as part of their broader effort to bring peace to the country in the aftermath of the election and the riots that followed. The best advisory rulings share three properties: unanimity, specificity, and practicality. First, as with ordinary judgments, it is always better if the advisory ruling is unanimous. A unanimous judgment resonates more powerfully in the jurisdiction where the claim has arisen. If the court splits 11-10 on whether a set of facts runs afoul of democratic standards, that will be considerably less impactful than the court's 21 judges speaking in one voice, by a decisive margin of 21-0. Unanimity is a key factor in the usefulness of an advisory ruling. It matters also how well the judgment reflects the history, practices, and political dynamics of the local jurisdiction. The more familiar, the better, and the more likely the ruling is to be seen as relevant in that jurisdiction. This is a point about specificity. Local specificities matter, and the court's ruling, in order to be effective, should reflect its awareness of those local specificities. And it is important for the advisory ruling to be attentive to the legal, political, and social realities that make it difficult sometimes to fix problems in the infrastructure of democracy. It is ordinarily difficult to make reforms, both in law and in politics. Presumably, if the court issues an advisory ruling that confirms a violation of a democratic standard, the court will state that finding and explain how and where the wrongdoer has fallen short. This is an essential part of any advisory ruling the court would issue. But the court should also offer a roadmap for reform. How can the wrongdoer go from failing to meet the standard to satisfying that standard? The advisory ruling can be most effective if it makes an effort to answer that question. This third factor is about practicality. How to get from here to there, from democracy infringing to democracy enhancing? Limiting the function of an international constitutional court only to an advisory function would not neutralize all problems that currently undermine the idea for the court. The problem of authority remains. But the problems of enforcement and coordination would become less pronounced in the context of advisory rulings. That might be the court's best chance for success. Conclusion: 5 principles for an international constitutional court. An international constitutional court is a provocative idea at a time when democracy is under attack around the world. It might also be a useful shield in the fight to protect democracy. For now, though, as we discuss this idea of a new supranational court to defend democracy, here are 5 guiding principles for building this international constitutional court. Internationality: the court must be housed in an international organization whose member states are all the countries of the world. Inclusivity: this must include democracies, autocracies, and others in between. Even if autocracies are unlikely to abide by court rulings, they must be included within the court's jurisdiction. Representativeness: the judges of the court must represent the rich diversity of the peoples of the world, from regions to legal traditions to systems of government and beyond. Independence: the court must both be independent and be seen as independent. The selection of judges matters here: how they are selected, how long their terms last, and how and whether they may be removed before the end of their term. Advice. The function of the court is to give non-binding advice through advisory rulings, not to issue binding rules that are likely to be both unenforceable and disregarded. Those are the 5 principles that should guide the creation of any international constitutional court. The idea must be refined much more granularly than how it is currently defined in the report issued 10 years ago. It is certainly worth the effort, both because it is important to brainstorm ways to defend democracy and also because it is a way to bring allies of democracy together in a productive way to build something together. Perhaps in the process we will conclude that it is an idea just not worth pursuing. Maybe we will find an even better idea. That would be a victory. A victory for democracy in your country, and mine, and around the world. But the idea of an international constitutional court should not be rejected without more thinking about how and whether it would work. I will continue to think about it, and I hope you will, too.